Mr. Kirby.
Good morning, may it please my lords. I appear on behalf of the appellant in this matter, together with my own friend, Mr. Tom Bell. Also have Mr. Bell's pupil with us, but insofar as it's within my gift, I've promised him he won't be called upon. But that's Mr. Stratton. My own friend, Miss Heather Murphy, appears on behalf of the respondent. My lord, in the familiar words of CPR 5221, the appeal court will allow an appeal where the decision of the lower court was wrong or unjust because of a serious procedural or other irregularity. Normally those who stand before my lords on an appeal have to persuade my lordships that the decision below was in error. In this particular case, the matter was referred back to the judge under the slip rule, who acknowledged that there had been an error in the taking of the account, but did not consider that that could be dealt with under the slip rule. So the error in this matter, because we say there is a clear error, and as found by the learned judge in the slip rule judgment, the error in this matter was that the account was taken on the figures inclusive of tax, whereas all the directions up to and including the taking of the account had been for the account to be taken on the figures exclusive of tax.
Now, can I just interrupt you at this point? We have all, as you would expect, looked at the papers. And our current feeling, unless you persuade us otherwise, is that it will make for clarity if we work out at the beginning whether or not we should be looking at Mr. Malik's evidence. I assume that even without Mr. Malik's evidence, you say that you should succeed, but it seems to us that it would be easier to follow the argument if we know up front whether or not we should be looking at Mr. Malik's evidence.
Well, I don't need to rely on Mr. Malik's evidence.
No.
For the reason that I'm not seeking to persuade my lords as to precisely what the correct figure is.
Well, can we be clear? Are you applying Mr. Malik's evidence before this court or not?
No, I'm not.
Right, okay. So on what evidential basis do you assert that there is an error?
Well, my lord, the evidential basis is that the figures that were before the court on the taking of the account clearly, as we now can see from the evidence that was put before the court on the taking of the account, included the tax.
So what evidence do you rely upon to support that proposition?
My lord, the evidence is... My lord, forgive me just for a moment. The evidence is in supplemental bundle 2. Divider 39. This was the evidence put before the court on the taking of the account on behalf of Times Travel. This was part of the evidence, and then there's the further witness statement at page 275. At paragraph 11 on page 273, sorry, paragraph 9 on page 273, there's reference to the BSP website. That's data provided by Iata, and the reports can be downloaded from the website in PDF form. And on downloading these BSP reports on a fortnightly basis, paragraph 10, so it's agreed that all the parties agree that the BSP data is definitive data and is accurate and therefore not disputed. At paragraph 11, TTL has produced an Excel spreadsheet, which is extracted from the TTL back office. This software is connected to Sabre. Software picks up the relevant information, including ticket number, date of issue, routing, cost price to be paid to airline, taxes, breakdown of the tickets. The result of the search was exported from the software to Microsoft Excel format. The spreadsheet details total sales for PIAC in these periods of TTL. Now, what the claimants did, they also compared with the spreadsheets that have been produced by PIAC, the spreadsheets which did not comply with the debarring order.
All right, but before you get into that, where do we find the spreadsheet?
My Lord, I don't think you have the spreadsheet as such. What you do have for instance, pages 299 are the updated schedule of claim 299 and 300.
Sorry, what is this document?
This is a document that was, as I understand it, exhibited to the witness statements of Mr. Ahmad in support of the taking of the account.
You may be right about that, but how do we know that? Because, sorry, the way the supplemental bylaw is organised isn't desperately helpful because we only have the index in volume 1, not in volume 2. So this is tab 40, am I right?
I'm at tab 40, yes, my Lord.
Sorry,
schedule 45.
Yes, I thought you were at tab 45.
Well,
I'm sorry.
In terms of the witness...
My fault. 45, I misspoke.
Yes. The schedule's at 45, but my Lord was no doubt referring to the witness statement, which is at tab 40, and at paragraph 42 at tab 40, there is a reference to the TTL submitted a schedule of claim. It's provided electronically entitled Amended TTL Schedule for 7% NSR due for the 1st of November to the 14th June 2017.
Now, there is what we've got at tabs 45 and 46 are NTL schedules, aren't they? Not TTL schedules.
Well, my Lord,
And it's a different date range.
forgive me, page 285, my Lord. 285 is in fact
Yes,
page.
the TTL. Yes,
I should have taken my Lord to it, forgive me.
Right.
So 285 is where we see the figure of 2,669,302.51.
Sorry, say that again.
£2,669,302.51.
Sorry, you're going a little quickly for me, and I apologise for being slow. So we've now gone to the witness statement of Mr. Ahmad of, what's the date of this one? 19th of November, is that right?
Yes, that's right.
Just taking out of your course again, I haven't worked out. There are witness statements and there are affidavits.
Yes.
Why are there both? And how do they compare?
My Lord, I'm starting to wonder whether it would be helpful if I took my Lords through all the orders for directions, but I expect my Lords have probably looked at those. It's just that on some occasions there was a requirement for affidavits, on other occasions just witness statements.
And in
That's the
terms
short
of what
answer.
was before the judgment taking the account, he had before him the witness statements and the affidavits insofar as they predate the hearing of the account.
Indeed.
Yes, I found it.
Yeah.
Right, so going back to where we were, tab 41, page 285, is the document that is referred to in paragraph 42 of the witness statement of 283, is that correct?
That is my understanding, yes. It shares that heading.
Right. Okay. And so that gives us periods, total ticket sales, 7% NSR due, and a total, and then there's an interest calculation. Have I got that right?
Yes.
Okay.
My Lord, the claimants, so far as the schedule produced and spreadsheet produced by the defendants were concerned, compared their data with the data provided by the defendant, but in their notice of objection, complained that if I could just finish the sentence, my Lord, complained that the defendants had failed to show the tax changes in their schedules, in their spreadsheets. So had failed to show the tax. And my Lord, that is at tab 36, which is in bundle 2. And at 254, one can see the list of objections of times travel at 6C, the impact, if any, of tax changes upon the tickets. And there was more or less identically worded objections on behalf of Nottingham Travel at divider 38, page 266, at 5C. Now, of course, if the claimants were entitled to commission on the tax, then there would the impact of any tax changes, etc., would not have been relevant.
It says impact, if any. I mean, what they're saying in this document, as I understand it at the moment, is that the evidence, the data supplied by PNI is inadequate.
Well, my Lord, that's undoubtedly correct, because indeed the data was inadequate, which was the reason why the defendants were debarred from defending the account.
Indeed.
So, my Lord, I obviously cannot do anything other than agree with my Lordship so far as that is concerned. My Lord, the reason why I said I don't need to rely on the evidence of Mr. Malik is because I don't need to rely, I don't seek to persuade my Lords, in the light of some of the points made by my learned friend, both on the slip rule application and in her skeleton argument today, I do not seek to persuade my Lords as to precisely what the amount is, although we have given a precise amount. But the judge who carried out the account obviously accepts that he carried it out on an erroneous basis.
But how can you rely upon that judgment? Because at present, my understanding is that that's based on Mr. Malik's evidence, which you're not relying upon. In any event, it postdates the judgment you're appealing.
Well, my Lord, I accept it obviously I accept it postdates the judgment that I am appealing. But I would submit that if ever there was a case where one can show that an error had occurred, that it assists that the judge himself has said that an error has occurred.
But the reality is you're still seeking to rely upon evidence that was not before the judge at the date of the order that you're appealing. You may try and camouflage it by relying upon the subsequent judgment. The reality is the same.
Well, my Lord, can I have a very brief word with my junior, who I just heard whisper to me, before I answer my Lord's question? Mr. Bell, who obviously dealt with the hearing before the judge. My Lord, my understanding is that on the slip rule hearing, the judge compared the schedules, the spreadsheet, with the entries on the BSP PDF documents, which was evidence that was before the court on the original taking of the account, but the judge was not taken to the thousands of pages of the BSP PDF reports on that occasion, and that those documents, and there are examples in the bundle, that those documents were before the court on the taking of the account, but on the slip rule application, the judge was shown the difference between those documents and the sums that had appeared in the schedules and in the spreadsheet. My Lord, can I, if it would help, can I take one or two?
Yeah, I'm sure you should in a moment, Mr. Kirby, just so I understand where we're going. Mr. Malik exhibits what I think is BSP material at tab 49.
Yes.
And if I've understood what you're saying correctly, while that is an exhibit, Mr. Malik, you say that was before the judge.
Absolutely.
And therefore you say you can rely on
Yes.
that.
Yes.
And that has the columns which we've seen reference to.
Yes.
Just going back a stage to the schedules which were produced by the claimants, take, say, the one at page 285, the TTL one, which we talked to a moment ago. We see there that there's a 7% calculation coming, as you said, to about £2.7 million. And that's based, that represents 7% of the ticket sales figures that we see in listed in the column there.
Yes.
Can one, without at the moment referring to the BSP report, can one tell in some way whether those figures are tax inclusive or exclusive?
Well, my Lord, I can't, if my Lord is asking me whether simply looking at page 285 one can tell whether that figure is tax inclusive or exclusive, no, because it just says total ticket sales.
And can one get that, if not from that page itself, from the witness statements or affidavits of the claimant's witnesses?
What, the figure of 2669307, or whether it was tax or tax?
The ticket sales figures are inclusive of tax.
One doesn't get it in the claimant's witness statements or affidavits. One obviously has reference to NSR, and it purports to be putting forward a claim in relation to NSR. But we say, obviously, it wasn't NSR, because NSR had been defined throughout these proceedings from the first substantive judgment of Mr. Justice Warren.
And that I follow, I think. But to take that argument forward, I might have thought, you might tell me I'm wrong, that one needs to know that the ticket sales figures that are being given are inclusive of tax.
Well, my Lord, I think the only, the way in which that would be most clearly shown would be a spreadsheet that has every single ticket price on it, which is the spreadsheets that were before the court. And when it shows every single ticket price on it, you can compare, sorry, I'm pointing, one could compare a particular ticket sold on a particular date for a particular route with then the BSP PDF, because that would then breaks down that ticket price according to the price plus the tax.
Sorry, I'm a bit baffled, and I'm sure it's my fault for being slow, but the question we're trying to establish at the moment is whether there was evidence, I stress the word evidence, before the judge on the taking of the account which demonstrates the alleged error. Now, what my lord has put to you is that the documents you took us to, emanating from the claimants, setting out in a summary schedule their claim, which is, for example, the one at page 285, you can't begin to tell, because it simply gives total ticket sales and a 7% figure. So on the basis of that document, you've got no idea whether it's tax inclusive or exclusive. So where is the evidence that shows us that the figures that was before the judge at the time of taking the account, that shows us incontrovertibly that the figures that the claimants were relying on and putting before the judge were calculated on the wrong basis?
My lord, the evidence before the judge was obviously very lengthy electronic spreadsheets plus supporting PDFs. Those were the documents that had to be, which were put before the court, that were verified before the court. Now, it is, of course, right to say and acknowledge that the matter, those numbers were not challenged at that time. But those numbers were before the court. And as I said, if one went to the spreadsheet, which has the individual tickets on it, and that spreadsheet, if one then looks at a particular ticket for a particular occasion and compares that with the BSP PDF, of which there are thousands and thousands, if you compare one with the other, on that evidence that was before the court on the taking of the account, one can see that for that particular ticket on the 12th of January 2012 or whatever it was, that the sum of £600 in fact comprised £400 plus £200 tax. I'm not obviously giving specific figures, I'm just trying to illustrate the point that that was the evidence before the judge on the taking of the account.
Mr. Newey, is this a fair summary of the position? There were the schedules which contained an annual total that you've shown us in, I think, tab 41, which doesn't say whether it's in or exclusive or inclusive of tax. The point you're making is that in the data, those tables which are exhibited by Mr. Malik but were before the court, the numbers in there would allow one, if one chose to do so, to total them up and produce a figure which showed that the total in the schedule was inclusive of tax. But those spreadsheets didn't actually contain numbers, totals that you could compare. They just simply have all the data in, and if someone had done the job, they could have added it all up and shown that was the case.
If someone had well, my lord, again, forgive me for a moment. The total in the spreadsheets, if one didn't indicate that tax had been included, the total of those figures came to, or rather the total of those figures was the figure of 2,699,302.51, by way of example, on page 285. Those totals were checked. What was not done was that those totals were not then compared with the evidence that was before the court in the form of the PDFs.
Can I just try breaking that down? Looking at the BSP material that Mr. Malik has exhibited, but which you've explained was before the judge, one can clearly see the split. But the schedule we see at tab 41 is, on the face of it, not simply based on the BSP material. Now, in terms of what the claimants were producing, was it possible to discern that their sales figures had all these particular components in terms of particular ticket prices, which one could then compare with the BSP schedule, or not?
Well, we know that they did have the breakdown of the fares because that's said in the witness statement, which I mentioned right at the very beginning. So we know that they did have information that showed the tax element. I can take my lord back to that if that would help.
The wording is singularly unclear to me. I mean, quite what it means, I find quite baffling.
Can you just take us back to what?
Yes, my lord, I was looking at tab 39.
Yeah, it's this expression, taxes, breakdown of the ticket, etc. I mean, what exactly does that mean?
Well, my lord, I would submit that taxes breakdown of the ticket means that it shows what element of the ticket is in respect of tax. Obviously, we're dealing with this travel agents who are selling flights, and any of us who have been on a plane know that a significant element of a airline ticket price involves tax.
This is air passenger duty, is it?
Whatever the taxes, yeah, forgive me, I can't remember precisely what they're all called now. But and the whole basis of the remuneration of agents in the travel industry, as one can see from, if necessary, from the Iata Resolutions, is on the basis of sums net of tax.
Yeah, but you need to read on. A search query was created to pull ticket data from all PIAC tickets issued by TTL with the parameters of date, ticket number, cost price, sale price.
Yes,
so according to that, it's impossible to tell whether that is inclusive or exclusive of tax.
Well, my lord, what the claimants have done is they have then chosen those parameters. So they have put before the court the cost price paid to PIAC via BSP, which will include the tax, because that's the amount that they've got to pay over to...
you say that, but where's the evidence?
My lord, if I can go to page 256 for a moment. My lord, this was a statement from Mr. Ahmad as part of the list of, or rather, this was the list of objections.
Oh, yes. Yeah.
But signed with a statement of truth by Mr. Ahmad, so it's not his statement, but he's signed it.
Did you say 256?
256, yes.
Well, I've got a table. It says PK Web RBD at the top.
Yes, it's the spreadsheet which has then somehow been printed out in portrait rather than landscape, which doesn't exactly help. And
this is Schedule 1, setting out where there's no information. So this is referred to in paragraph 7A. No information at all for 55272 out of 99617 records. See Schedule 1.
my lord, yes, this is Schedule 1, no information at all. And the point that I think my learned friend Mr. Bell is wanting to make is So what was before the judge? So this is an example where you have the particular ticket number. So there's very long numbers at the bottom of 256. So that is before, that information is before the judge. If you then, I fear my eyesight might not be good enough at this point. If that is then compared with the PDFs, then that enables the judge to compare whether the sums referred to include or exclude tax.
So just pausing there, if we take the first completed column on 256,
yes,
we get a particular ticket number with a ticket cost price to agent, which is £398. This is derived from the PIAC schedule, is it? Are the claimants saying, look, we've looked at the PIAC schedule, we see this information given there, and we don't think it's good enough?
Well, that would be my understanding from as Justice Arnold pointed out.
This is the stage where you're saying they're contending you're debarred because you haven't complied with the orders. So can I just approach this question in a slightly different direction? Could I, and I apologise for doing it in this way, but I think it may actually help. Could we take what the judge actually said on the account?
Yes.
Okay.
So in the
call bundle, tab 6, page 78. So look at paragraph 112. Conclusion. I find on the taking of the account, the first claimant is entitled to judgment for the following amounts. 1, 2669 302.51. So what we can see from that is that he is finding proved the figure in the schedule to which he took us, which is
yes, the figure we looked at, mate.
285. And when you look at 285, as we've discussed already and as you've accepted, all that gives you is total ticket sales, 7% NSR. So you've got no idea, based on that schedule, what the total ticket sale figures include and do not include. You don't know, off the face of that schedule, for example, whether there's a fuel surcharge included or not.
Of course I accept that.
So, what evidence was there before the judge, as at the date of the taking account, that tells us that the figures that he was relying upon were erroneous?
Well, there's only so many times I can say the same point, and we'll put it slightly differently, in that in order for an account to be taken, obviously it's important that parties put before the court schedules, etc., of invoices and spreadsheets showing various details. The defendants failed to put the proper evidence before the court, but such evidence as was put before the court comprised both spreadsheets showing individual ticket prices and the information provided by IATA, which would show the breakdown of each ticket price. And from the breakdown of each ticket price, one could simply look at one ticket price and see, did that or did that not include tax when it went to form part of the total sum from which 7% equaled 2,669,000.
All right, but you see, the reason why I'm struggling is that, at least in theory, you might be in a position to say, well, the judge found proof the amount claimed in the schedule. Here's the schedule. The schedule is based on underlying documents. We can go from the schedule to the underlying documents, and the underlying documents show us the error. But you haven't quite made that submission.
Well, my lord, that is my submission.
But is it? Because where are the underlying documents for the schedule?
Well, my lord, the underlying documents would be, or the underlying documents that were before the court would be the many thousands of PDFs from the BSP, which is accepted to be the definitive data so far as ticket sales are concerned.
I follow that. How do we know the relationship between the BSP data and, say, the figure we get at page, or the figures we get at page 285?
My lord, the connection between the 285, if one looks at 285, and so looks at the period, for example, 1st of November 2012 to 31st December 2012. So you've got total ticket sales for that period of 2.281 million. If one went to the PDFs for every ticket sale during that period, and obviously there would be hundreds, there might not be thousands just for that, but there would certainly be hundreds. If you went to every PDF from that, the total on the PDFs, including tax, would have come to 2281,963.74. Because the claimants, in putting the evidence before the court, we say, failed to remove the tax element.
So,
and I'm not sure it's ever been suggested that the claimants did remove the tax element. And bearing in mind the directions that have been given by the court for a period of over two and a half years with regard to the matter, we submit that if were it the claimant's case that it put before the court figures which excluded tax, then I would be in a difficult position. But in our submission, unless the claimant's case is that the figures that it put before the court excluded tax, then the claimant has put before the court evidence that was not in accordance with all the directions for the giving of evidence and for the swearing of affidavits to justify that evidence. Now, the reality was that before the judge, on the taking of the account, the evidence had been produced. It was assumed wrongly that that was net of tax, or alternatively, no one had turned their mind to it.
presumably the latter is the more likely.
I think it's probably, to be honest, I think it probably is the latter. No one had turned their mind to it. As I say, the claim was for NSR, which is clearly defined in the substantive judgment. And is then referred to, that definition is then referred to in subsequent directions.
Yeah, well, we'll get into that in due course, no doubt. But so when you say you refer to the PDFs, you're relying upon documents of the form that we have at tab 49, is that correct?
Give me a moment. If those are examples, yes. sorry, forgive me.
And so how does this document show the error?
Well, my Lord, if we just take the first page, 318.
Yeah.
So one has obviously a number of columns. The first one is currency, document number. One then has...
So document number, are you asserting that that's ticket number?
I believe that is ticket number. I'd have to say...
so you don't get that off the face of the document, so where's the evidence to tell us that document number means ticket number?
Well, my Lord, I could... well, I'm going to park that just for a moment. I will come back to it. My Lord, one then has the issue date.
Well, you next have something called CPNS. What's that?
I've no idea. I'm not sure even my learned junior does, but I've no idea, apart from the fact that it appears to be, as far as I can see, every single ticket appears to be... Oh no, there are one or two that are VVVV, but I'm afraid I cannot assist the court on that. One has issue date, one has gross fare cash. So that first one, for instance, £340. Then one has tax fee cash 207.55, I think that is. Then various columns which have nothing under them, so gross fare credit, tax fee credit. And then one gets the payable balance of 547.55, which is obviously the total of the gross fare cash and the tax/fee cash.
So that suggests that very roughly 2/5 of the total is tax. Is that correct?
That is correct, which is why we say the overpayment is so substantial. These are obviously primarily flights to Pakistan, so the tax is going to be very substantial.
Why? So,
well,
I was giving evidence. Is this UK tax or Pakistan tax? Or?
My Lord, I think it's UK tax, but my Lord, no, I end up giving evidence about my knowledge of paying for airline tickets.
I'm sure that air passenger duty is affected by the length.
It certainly is, and it goes up according to the length and whether you're flying with a particular airline. So, my Lord, on that particular example, it's 340 plays 207. My Lord will see further down that there would be, for instance, some tickets that were sold considerably cheaper. There appear to be 240, and some literally at £22. There's one at £22.
So, if it's as simple as simply looking at this document and saying, well, we've got the gross fare cash, we've got the tax fee cash, and we've got the payable balance. If it's as simple as simply looking at that, then that's something that your clients could have pointed out as soon as these documents were produced.
My Lord, I can't shy away from the fact that we could and should have certainly with the benefit of hindsight, should have spotted this. But the evidence that the claimants were required to put before the court was in accordance with the directions that had been given for an account to be taken of NSR, as defined in the substantive judgment. Now, if the claimants put before the court evidence on a different basis, then clearly that is something that, again, certainly with the benefit of hindsight, one could have spotted. But it is the claimant, we say, not helped, I have to accept, by the defendant's failure to put in the relevant schedules. But it's the claimant's evidence that is then relied on for the purposes of the account. And to date, there has been, as I understand it, no suggestion either in this court or, insofar as it's relevant, on the slip rule application. There's been no suggestion that, in fact, the figures that were put before the court were exclusive of tax. So, obviously, the net result is that the claimants between them receive over £2 million, which, because they receive a commission on tax. Now, we say, as my own friend Mr Bell did on the slip rule application, we say it should now be a fairly straightforward exercise to export from this data the tax element. We have done that. If those figures are challenged, they'll no doubt be challenged. But we have done that, which is why we come to the conclusion that the amount overpaid is over £2 million, because tax does form a substantial part of the overall fare paid by the customer.
Can I just pause there one moment? Going back to the material that was before the judge had available to him, he wasn't taken to it in any detail, but there was available in the court all the BSP data from which one could extract gross figures including tax and also net figures excluding tax if one totted up all the different columns. This may be because I haven't quite got to the bottom of it. It's not obvious to me at the moment that the figures that ultimately the judge used precisely tally with those columns.
The part of the judgment which my Lord Justice Arnold took me to, that particular figure obviously was the same figure as in the schedule that was exhibited to the witness statement of Mr Ahmad. There was an issue with regard to Nottingham Travels, I think I've got it the right way around, Nottingham Travels commission claim as to when the cut-off date should be. So the judge on the taking of the account gave a cut-off date. Forgive me, I can't remember off the top of my head what it was. I think it was some date in 2017, and said, and if you want anything after that, you'll have to, well, hopefully you won't have to bring another action, but you'd have to bring another action. So that was the reason why on the Nottingham schedule, the amount on the schedule exhibited by Mr Ahmad is not the precise sum then reflected in the account judgment, because the issue of period was a matter for the judge to consider. My Lord, I must point out, of course, that my own friend Mr Bell was not allowed, I mean, and I make no criticism of the judge in this regard, because obviously if a party has been debarred from defending, they don't get to defend, it stands to reason. But other than the period, which the judge indicated he may have some assistance from Mr Bell, Mr Bell could not, for example, make submissions with regard to the bulk of the material that was before the court.
Can I just try and bottom it out for a moment? So we say the judge had before him all the BSP material, from which one could have, had one wanted to, have arrived at net figures by totting up all of one column. On your case, was it then a simple matter of multiplying that figure by 0.07 to get 7%, or is there more to it than that?
My lord, on our case, it's simply a question of doing that.
I have in mind that Ms. Murphy's skeleton argument arrives at differences between sums calculated on PIAC's figures and other sums. I must admit, I can't precisely remember which boxes I have in mind, but what is the explanation for, or perhaps I'd be better wait for Ms. Murphy to explain, what's the explanation would you say for those differences?
Well, my lord, I think in the light of my learned friend's skeleton argument, and indeed the arguments that she put before the judge on the slip rule application, we have accepted that we cannot say to this court, this is precisely the sum that is due, because my learned friend does raise certain points. We don't think that they have any substantial merit. But there is, for example, a point with regard to, I'm in danger of getting my acronyms wrong, APS. Yeah. With regard to APS and the extent to which what's called YQ, and YQ is a fuel surcharge, has to be deducted for the purposes of calculating APS.
So just pausing there, there were several different types of claim, and I'm not going to get the descriptions quite right. The APS claim was a particular type of claim. With the big 7% claim, is there such a dispute there on your case?
I don't believe so. My learned friend may. My lord will recall the PDFs of taking to. The figure in relation to tax, there could be an argument that that figure includes YQ. If it did, then YQ would have to be added back onto the first figure, because we accept that for the purposes of NSR, the claimants are entitled to 7% of the net ticket price, including YQ. So that would be the only qualification.
That's quite a big qualification.
Well, it's a big qualification.
The judge could not have worked it out at the time had anyone raised the point.
Well, my lord, yes, I accept that. But if the judge had been told, this is our claim, we claim 7% of this figure, and this figure is the tax-inclusive figure, it is difficult to imagine that the judge would not have said, but I thought NSR had been defined throughout as a tax-exclusive figure. And if the net result of that had been that the judge couldn't be satisfied what element was YQ, what element was tax, then presumably the judge would have adjourned it for that to have been clarified.
But how is any of this going to happen in circumstances where your clients were debarred from defending?
Well, my lord, it's going to happen because the court will and should proceed on the basis of the directions for the account and on the basis that the evidence that's put before the court is in accordance with those directions. Now, if the evidence that the court is being invited to accept is something other than the evidence provided for in the directions, then that should be, in our submission, be pointed out to the judge.
I mean, a difficulty is this court regularly allows new points to be run if the relevant evidence was available at the trial and there's no need for any further hearing. But you accept, as I understand it, that the relevant evidence was not available at the trial and there would be a need for a further hearing if we allow this point to go forward.
Lord, I think I have to accept there would be a need for a further hearing.
Even as to NSR, because we don't have the YQ element identified.
Forgive me again, my lord. I don't know whether this came out of my lord's reading of the slip rule judgment, if that's been read, but on our case, YQ was merged with the fare, so YQ became part of the fare. I wonder if I could just remind my lords of some of the background to this case. And my Lord Justice...
Before we get into the details of YQ, are you seriously submitting that, assuming that we were to allow the appeal and remit the case to the judge to put it neutrally, a recalculation, the judge would be in a position to arrive at a correct figure with no further evidence?
Well, on our case, my lord, yes, but actually, if I can take the point I was going, or if I can go back to deal with the point, that might explain why we say yes.
Okay, but before you get on to your explanation, would you accept that if the case is remitted to the judge, your clients are still debarred from defending?
My lord, if the matter is remitted, we are still debarred from defending. But the judge will, in order to carry out the account, will want to carry out the account in accordance with the directions that he and other judges have given. So the judge will have to be satisfied that the evidence before him shows...
But I don't understand this, because why will he not do exactly what he did last time, which is he was to say, the claimant relies on their schedules, defendant debarred from defending, I therefore accept the figure in the schedules.
Well, because the judge will say to Ms Murphy, the figure of that you rely on, does that include or exclude tax? And if the response from counsel is that it includes tax, then the judge, well, this is a little bit hypothetical, but the judge presumably will say, well, wasn't the direction for it to be exclusive of tax? And didn't I give a direction for the filing of evidence?
So you're supposing that the judge turns himself into an investigative tribunal as opposed to a tribunal deciding matters upon the basis of adversarial argument?
No, I'm assuming that the judge will conduct the account in accordance with the directions and will be satisfied on the balance of probabilities that the evidence before him is in relation to tax exclusive amounts.
I must say, at the moment, Mr. Kirby, your submission sounds like you're benefiting from the fact that you were debarred below, which I don't find very attractive.
Well, my Lord, I understand my Lord's observation. My Lord, what we say is that the claimants should not benefit from putting evidence before a court which is not in accordance with the direction that the court gave. And when that...
submission that the defence makes defending a claim. You go to court and part of defending a claim is to say that there's something wrong here. This isn't in accordance with the directions. The judge can decide. That's exactly what defending an account might involve.
Well, my Lord, that is... Can I take a slightly different example? Sorry, forgive me, I interrupted, my Lord.
Right.
So there's an account, there's an order for an account to be taken for the period 1st of January 2015 to the 31st of December 2016, so 2-year account. The claimant, in fact, puts before the court figures for 3 years, from the 1st of January 2015 to the 31st of December 2017. That's the figure that's put to the court. It's for 3 years, not 2 years. There's no one there to defend it. In our submission, it would be a strange situation if the court is then effectively just to rubber stamp that figure because that's the figure that's been put before the court. That, in our submission, does not appear to be dealing with the matter justly if the direction has been for that 2-year period and yet the period that's been put before the court is a 3-year period.
What if the facts were different and the party receiving on account of inquiry in good faith puts forward evidence to the court which complies with which states on its face that it complies with the time period you're talking about? There's nothing to alert the judge to think there's anything wrong with it at all. In fact, we know, let's say it isn't right, but let's assume that good faith puts it forward in that way, and the other party's debarred from defending it. The judge accepts it. What's wrong with that?
Well, my Lord, if a party knowingly put that evidence before the court, knowing it to be false, then one...
Set aside the judgment for fraud.
Yes,
in that scenario.
Yes. Well, sorry. My Lord Justice Arnold beat me to it. Yes, that would be the consequence of that.
Exactly. So that was why I put it the other way around. Seeing a party put it forward in good faith and said, "There's my evidence," and the judge has no reason to doubt it in any sense or think it's not in accordance with something. That's what defending a case is. You turn up and say, "Well, actually, there's been a mistake here," or it's actually more than a mistake. It's wrong.
Well, I accept that's what's defending a case is, but putting forward a case is also putting forward a case within the confines of what you have been permitted to put forward. And in this case, the claimant was permitted to put forward a case based upon net fares. It wasn't permitted to put forward a case based on gross fares. It's probably unhelpful me using those phrases because they've got slightly different meanings, but I think my Lord understands what I'm saying.
Because in fact, it's the gross fare in that table.
Yeah. Well, when one is putting a case to a judge, even if there is no one, in fact, perhaps even more so when there's no one there on behalf of the defendant, if one put before the judge a case that was beyond what had been directed, then in our submission, that shouldn't happen. Now, my Lord, I take on board the point my Lord Justice Newey made earlier, which is that it is almost certainly a question here that no one actually turned their mind to it at the time. And I hope I have fairly accepted a number of points that have been put to us. So no one probably turned their mind to it at the time. But the result of that is undoubtedly, on our case, a very significant windfall to the claimants. There's no basis in the claim at any point on which they could be entitled to a percentage of tax. It's not the way IATA works, and it's not the way that this particular contract works. So if they have put before the court evidence that includes tax, then they've got away with something, and they've got away with £2 million.
They got away with slightly has a flavour of fraud, which you're quite correctly disavowing.
I clearly, as counsel, I'd have no insufficient evidence to suggest anything by way of fraud. But they have got away with it in that the evidence put before the court did not follow the directions that have been given, and the evidence before the court has resulted in them receiving a significantly greater sum than they were entitled to if the account had been carried out in accordance with the directions.
What troubles me, just picking that up, is if it's always the case when a party is debarred from defending a case, that the outcome may very well be that the amount of money they're required to pay is higher than it would have been if they'd been there. That's I mean, it's not inevitable.
Well, that's undoubtedly the case.
But it is the case.
And
therefore, one can always say, after a hearing in which a decision has been made, which debarring has been ordered in advance, that the result is higher than what you might characterise as being the right result ought to have been, when right result means the result that would have happened if both sides had argued the case properly. And that's what I'm struggling with, is how that's different from the current circumstances.
my Lord is, of course, quite correct in pointing that out. And indeed, that happened in this case also. So one of the issues that the judge had to consider was whether the 7% should apply to all fares, or whether, in fact, the defendants had given credit on some, and therefore whether, in conducting the account, whether a certain amount of credit should be given to the defendant. And in fact, the judge proceeded on the basis that effectively is de minimis any credits have been given, and therefore allowed 7% on it all. Now, that is an example that, as my Lord has indicated earlier, that is the sort of point where you say, well, I was going to say tough, but too bad. You've been debarred from defending. Yes, you could have run that point at great length, and you might have been able to persuade me, but that's tough. That's what goes with being debarred from defending. We say that this is in a different category, because this is in a category that puts forward a claim that is outside the parameters laid down by the court for the taking of an account. And directions for an account obviously will normally provide for what the court needs to know in order to take that account. Now,
but it's a regular occurrence, particularly in intellectual property cases, that accounts are directed, and there are fearful arguments on the taking of the account as to what is properly to be included and what is properly to be excluded. It's in the nature of the exercise. So, in particular, you often get a lot of argument about what are proper deductions and what are not proper deductions. And frequently, the accounting party will be saying certain things need to be deducted, and the receiving party will say, no, you're not allowed to deduct those. And the court then has to decide. But obviously, if the accounting party is debarred from defending, then that's almost inevitably going to result in the receiving party being successful in its claim for the amount without those deductions that are in dispute.
But it was never in dispute, my lord, about tax, because the directions for NSR had always made clear it was net of tax. So the question of tax was never in dispute. It had been repeated. The definitions that are provided for in paragraph 8 of the substantive judgment are referred back to in subsequent directions with regard to the taking of the account. NSR is actually defined by reference to it being net of tax. My lord, what's been referred to as the substantive judgment, which I know my lords have read, is at divider 11 of the supplemental bundle.
Sorry, that's the account judgment.
No. Sorry, forgive me. The phrase substantive judgment has been used. I've just remembered about 20 minutes ago I was going to give a slight background explanation. My Lord Justice Newey may even recall some of the background to this, as my Lord gave permission to appeal with regard to the economic duress point, and my Lords will be aware of the decision of the Supreme Court, and indeed which upheld the decision of this Court. And so the case originally had included a claim with regard to economic duress. Times Travel, having had the decision in the substantive judgment with regard to economic duress, elected to avoid the new contract. Therefore, it was claiming 9% under the previous contract and a quantum merit thereafter, whereas Nottingham Travel didn't avoid the contract and was therefore entitled to NSR throughout. So when one sees in some of the directions references to, for instance, quantum merit, that is because those directions were given before the judgment of this Court with regard to the economic duress point. And obviously once the Court of Appeal had given its judgment, there were then directions effectively that put Times Travel and Nottingham Travel in the same position. And the APS element of the claim only arises post the new agreement. So, my Lord, at page 67, at paragraph 8, this is the reason I take my Lords to this is that this is a paragraph and terminology that is referred back to in subsequent directions and indeed decisions. So you've got there the definition of YQ, a fuel surcharge, variable surcharge levied by airlines, base ticket price, price of a ticket less tax and YQ, net ticket price, price of a ticket less tax, i.e. base ticket price plus YQ, The 9% is, as I say, under the previous agreement. And then at the bottom, net sale remuneration, a form of remuneration introduced by PIAC on the 16th of October 2010, so that was the new contract, in which the claimants were offered tickets at 7% below the net price, thus at a price lower than that at which PIAC offered them for sale directly to the public. And then there's a reference to Agent Productivity Scheme, APS, further commission paid to the claimants on top of net sale remuneration as incentive after specific tiered sales targets were met. So those definitions are, one goes back to on a number of occasions.
And just to state the obvious, where in net sale remuneration there's a reference to net price, that's to be taken as net ticket price.
Yes, and the judge rules on that subsequently. Says that they're taken to be the same, synonymous.
Yes.
Now, my lord, just while we're in that judgment, if my lord turn to page 69, you'll see references to, at paragraph 12, references to, well, what is in fact referred to as regulations, I think, and also as resolutions. I think, strictly speaking, they're resolutions, not regulations, but we're talking about the same thing. And these are the Iata resolutions. And those resolutions are then set out in paragraphs 13 through to 15. And one can see that as far as fares applicable are concerned, that excludes any charges for, this is at the top of page 70 and indeed in the middle of page 70, excludes any charge for excess baggage or excess valuation baggage, as well as taxes and other charges collected by the agent. My lord, that judgment, or rather the order following so, my lord, while I'm in the judgment, can I take you to a couple of other paragraphs just to save going back to them later? If my lord turns to page 110, there had been an issue, as I understand it, as to whether net sale remuneration actually was commissioned for the purposes of the Iata regulations, and the judge said, well, it is. It's a way of remuneration, and that's in a sense dealt with at paragraph 208, 4 lines up from the bottom. It does not strain the language to bring within its scope as a remuneration paid a provision of tickets at a discount. There's then a section on the YQ issue. And says at 211, the reason that commission, this was in the case referred to in the previous paragraph, the reason that commission was not payable on taxes was, of course, because they were expressly excluded by the definition of fares applicable.
I beg your pardon, I've lost the reference. Where is that?
Page 211. Sorry, forgive me. Paragraph 211 at the bottom of 110.
Thank you.
So it's referring there to the IATA regulations and the fact that taxes were expressly excluded. And you'll see on paragraph 214, that one of the issues was whether, since YQ formed part of the fares applicable, it ought in principle to be subject to the same commission as any other element of fares applicable. And we accept that for the purposes of the 7% that it must include the YQ, because that's what actually the judge found. Because you'll see over the page at 218, about 8 lines up from the bottom, it was not in any case open to PIAC to remove YQ from the part of the fare which was subject to commission, even if clear written notice of the intention to do so had been given.
Sorry, where was that?
Forgive me, it's page 112,
Yes.
paragraph 218,
Yes. I see, yes.
about 8 lines up from the bottom.
Yes.
So then, again, just to, in a sense, give it a certain amount of history, page 113, paragraph 224. That's a finding that immediately prior to the service of the notice on the 14th of September 2012, each of TT and NT was entitled to 9% basic commission, including the YQ element of the fare. Well, at page 126, paragraph 279, we have that TT was put to its election, whether or not to be bound by the new agreement. Obviously, that's all now, in a sense, water under the bridge. And then at 280, if it elects not to be bound, then it's entitled, subject to the limitation point, to payment of 9% commission on the YQ element of the fares. It's entitled to basic commission on the net ticket price, i.e. including the YQ element of the fare. The order following that judgment is at divider 12, page 128. And the order for the account on page 129, obviously that has, to some extent, was then superseded because paragraphs 1, 2 and 3 were the claim under the old agreement if the new agreement had been avoided. But you'll see that at little 4, TTL must give credit to the defendant for the value of any benefit already received in the form of net sale remuneration. And over the page, NTL, who had not avoided the contract, so it's entitled to remuneration from 31st of October 2012 in the form of NSR for the sale of air passenger transportation. And then at little Roman 3, and it's entitled to be paid commission in accordance with the defendant's agent productivity scheme. So that's the first order or direction for the taking of the account. My Lord, can I then take you to divider 20, page 152? I've just realised, do my lords have dividers? Because otherwise it's not very...
I personally do.
Yeah, right. Otherwise it's not very helpful me saying it. But page 152, thank you. So this decision, following the retirement of Justice Warren, now Sir Nicholas Warren, this is a decision and ruling concerning the basis of the second claimant's remuneration. Bear in mind that at this time still, the first claimant has avoided the new contract by reason of economic duress, or what was said to have been economic duress. And can I take, my lords, to paragraph 9, which is on page 155. it follows from this discussion that in the taking of the account, NT is entitled to claim that it should have been it should have paid PIA for a ticket only in amounts 7% below the price at which PIA was offering the ticket to the public. I shall come later to the difficulty which arises from the fact that PIA sold the same ticket to the public at different prices, e.g. over the counter in its physical office and via internet sales. But note that the consistent description of NSR makes no reference to service charge or YR on the part of PIA. This conclusion reflects the definition of NSR, which I set out in paragraph 8 of my main judgment, namely that NSR provides for a price to agents of 7% below net price, which must be the same as net ticket price, taking the point that my lord put to me a few moments ago. That is to say, the price of ticket less tax or base ticket price plus YQ.
Is the reference to YR a mistake? Should that be YQ?
I think there might be something called YR. Oh, yes. That YR was a passenger service charge, but I think that came up for decision in another part of the case and is lost. Yeah. There was one of the hearings was over what was referred to as revised NSR, but the defendant was unsuccessful in seeking to persuade the court that revised NSR should be applied. So it's in the current purposes, it's a red herring. So paragraph 11, accordingly, my ruling is that NT is entitled to a reward, which for reasons previously given I consider to be remuneration in the form of NSR. If I could then, the actual ruling is at page 157. At the foot there, I therefore rule as follows. NT is entitled to reward or remuneration based on the application of NSR as described in my main judgment in accordance with this decision and ruling. NSR is to be applied on the basis of lowest published fare, at which public can acquire tickets direct from PIA. So we say that following that substantive judgment, that was the first orders for, we had the first orders for the account. Now we have a ruling with regard to precisely what that means. Again, we are being told, or the parties have been directed as to what NSR means and that it is net of tax. Well, the next order is indeed at the next page, page 159. And you'll see from the third recital that obviously at that time there was still a quantum merit claim. So over the page of page 160, paragraph 3, little 1 of the order of the 14th June 2017 is to be interpreted and applied on the following basis. NSR carries the meaning given to it in the judgment dated the 14th of June 2017. So the submissions that have been made, I think by my own friend Mr Bell, that somehow there was some revised NSR, were unsuccessful. No, we go back to paragraph 8 of the judgment of the 14th of June 2017. Lord, we have the start of the directions with regard to the provision of spreadsheets, etc. So you'll see at paragraph 2, PIA must produce and serve on NTL an Excel spreadsheet in the attached form. Each ticket must be a separate line entry. Each line entry must be supported by documentary evidence from BSP in native format.
Now, when I was looking at this earlier, I was looking for the attached form and I couldn't find it. Is that because, in fact, there never was an attached form, and that's a drafting error, or is it because the attached form has not been included in the bundle?
My lord, I think there was an attached form. Can I take just ask my own friend, Mr. Bell? My lord, my learned friend's going to give me the page reference in a moment, I'm hoping. And I recall now that he told me about this yesterday, so I should remember. Which is that whilst the form itself is not there, the headings are set out, I think, in one of the skeleton arguments. From recollection, my lord, one of the headings is not, for instance, tax, because I'm sure that's a matter that my lord wants to...
Well, sorry, I may have not been sufficiently paying attention to what you just said, but is the answer to my question, was there an attached form, yes or no?
Yes.
Right, so there was an attached
Yes.
form. Where is the attached form in the bundle, or is it not in the bundle?
It's not in the bundle. What I was going to take my lord to is page 465, divider 61, I think. But anyway, page 465 in the second volume of the supplemental bundle. And this is my own friend's skeleton argument, my own friend for the claimant's skeleton argument. I take you to it just to, because she does set out there, my own friend sets out what the headings of the spreadsheet were.
Right, and as you were saying a moment ago, there's nothing there about tax.
My lord, there is nothing there about tax, but my lord, the direction itself obviously makes clear that that is the basis on which the account is to be taken.
But just a moment, so far as your client's obligation, which ultimately it defaulted on, is concerned, you were required to produce and serve on NTL, in this case, an Excel spreadsheet in the attached form, and we learned from this that the attached form did not include any tax information.
It did not include a separate column with regard to tax, no.
And am I right in understanding that the point, presumably, although it's not spelled out, is that the price on that spreadsheet was envisaged to be the one that should be used to calculate the sums due?
Well,
it would seem a bit odd if it wasn't, but I just want to draw that out because it doesn't happen to use the same language.
that's a problem, obviously, and obviously I would like to make that submission. I'm not sure if I can because it says what it says.
Yeah. You might say that's what it must have been.
Well, bearing in mind the direction for the account, and the constant reference back to paragraph 8 of the substantive judgment. Bear in mind the direction for the account. Obviously, that element has to be known in order for the account to be taken. Otherwise, how do you take the account?
Yeah. So on your case, G, lowest published fare, should have been given as exclusive of tax, but including YQ.
Yes, but can I make clear, because I don't wish in any sense to mislead the court, obviously, that when we did provide information, we went and provided it including the tax.
I follow that.
So and you know that obvious criticism can be made with regard to that. But in order for the account to be taken in accordance with the directions which are then subsequently repeated, the court has to know what the tax element is. So yes, that would be my submission.
So, in summary, you were directed to provide information by spreadsheet. The information you provided by spreadsheet included the tax when your submission now is that it should have excluded it. And moreover, you couldn't tell that off the face of the information because there was a separate column for tax.
My lord, of course, puts it very succinctly. Yes.
So, at least at this stage, the origin of the mistake is your client's.
Well, we certainly didn't help the position. Will my lord forgive me? My lord, but I'm grateful to my friend Mr. Bell for reminding me that the purpose of this spreadsheet was in fact to see whether the discount had been given. So the issue at that point was, has a discount been given? Now you could do that with reference to tax inclusive or tax exclusive. The issue was, has a discount been given? Those spreadsheets that were provided did not provide the necessary information in order for that issue to be determined. And the judge, taking the point that Honourable Justice Birss made earlier, as a result, no credit's given.
I mean, the danger possibly for you there is, given that the point was to work out whether or not you'd afforded a discount, it was in your interests to make the published price as high as possible. And therefore, at that stage, it was in your interest to have a tax-inclusive price, which could be compared with what you'd sold to the agent for.
I'm not sure if that's necessarily right or not, because so far as the comparing between the two is concerned, I think so long as on each occasion you're either inclusive or exclusive.
And I see that. So is it the case that when you were giving the ticket cost price to the agent, you excluded the tax? And when you were giving the lowest published fare, you included the tax? Or did you adopt the same policy in both cases?
I think we adopted the same policy in both cases. It was always inclusive of tax.
I see. So, yes, I see. So, yeah. And just coming back to what the judge had ordered, he said there must be the spreadsheet. He also directed that each line entry must be supported by documentary evidence from BSP in native format. How would that have compared with what we see at tab 49, where we see the BSP table?
Well, that is those are the documents.
So in that's
sense, the native format of the BSP documents.
The material that you were directed to provide would include the breakdown.
And the airline would have that, and the agents, as I understand it, would have access to that.
So that would mean that if one took the spreadsheet that was produced and the BSP native format, you could see that your client had produced the tax-inclusive figures.
Yes.
In accordance with the order that had been required of it.
Yes. This is a point addressed earlier, that if one compared the particular line, and going back, because I did say I'd come back to it and never did, going back to the point that my Lord Justice Arnold raised with me, that particular number we say is the ticket number, which I think was in the second column. But yes, if one took a particular ticket from the spreadsheet and found the particular BSP PDF and compared those two, one would then see what was inclusive and what was exclusive of tax. Well, if I can just very quickly turn over to page 161, again within this order. So the paragraph 8A, the quantum merit claim was to be payable as NSR, and little b, NSL carries the meaning given to it in the judgment dated the 14th of June. My Lord, over the into the next section is a judgment. Forgive me, my bundle has exploded. A judgment again of Sir Nicholas Warren, July, and you'll see from the top of 166 that this was the decision on the basis of the quantum merit and directions in the TT account. And again, there are references to the fact that NSR was to have the meaning that it was given in the order from June 2017. So, for instance, at paragraph 9 on page 167, in paragraph 3 of their particulars of claim. See, I haven't taken my lords to any of the actual pleadings in that. But in paragraph 3 of their particulars of claim, the claimants set out the meaning of NSR in accordance with PIA's defence in this action. It's quite clear that in referring to NSR throughout the account, particulars of claim, the claimants are referring to NSR as so defined and not referring to revised NSR, which I've discussed previously. So again, it's rejected the airline's argument that there's some form of now revised NSR. It's the original NSR, and that's the one that had been referred to in the judgment. My Lord, if I can then take you to divider 23. It's an order of Mr. Justice Barling. None less order, but again, the recital, fourth recital, refers to quantum merit being in the form of NSR. And if one can then go to divider 25. This was amending the order of Mr. Justice Warren on the 14th of June in the light of the Court of Appeal's decision with regard to the economic duress point. So page 177, you'll see in the middle of that page, TTL is entitled from the 31st of October 2012 to remuneration in the form of NSR for the sale of air passenger transportation. And then TTL is in addition entitled to be paid commission in accordance with the defendant's agent productivity scheme. Because the Court of Appeal found that the new contract did apply, and therefore under that new contract, TT would now be entitled to APS, which was something of an incentive to get agents to sign up to the new contract.
Now, by this date, which is the 20th of May 2019, first of all, we had the defective spreadsheet from your side, plus the affidavits from the claimants that come in with their calculations. And we can see that page 176, penultimate recital, and paragraph 2, that there was an issue as to whether the effect of the non-compliance, or the alleged, at that stage it was the alleged non-compliance with Mr Justice Barding's order, was that your clients were debarred. So it would have been open to your clients at that stage to say, actually, when we provided the spreadsheet, we made a mistake. We provided data inclusive of a tax that should have been exclusive tax, and moreover, the claimants have done the same thing in their affidavits the 29th of March. And it would have been open to your clients at that stage to say, well, even if we're debarred from defending in other respects, we should be entitled to point out that mistake to the court.
Well, my Lord, benefit of hindsight, yes, but with the benefit of hindsight, I probably wouldn't be standing here anyway. But my Lord, I accept that that the information that had been put before the court at that stage in those documents had been tax-inclusive figures. As I say, because I put it no...
Why, having failed to take the point, as it were, before the shutters came down, namely before the stage at which was either determined or, as in fact as it ultimately occurred, accepted that you were in default and therefore were debarred, why, having failed to take the point then, should you be permitted to take the point not only post the acceptance that you were debarred, but post-judgment and post-order?
My Lord, because this court should not countenance the putting before the court on the account of evidence that was outside the directions, the result of which has been a windfall for the claimants. It is a matter of...
When it was your clients that first made the mistake.
We've made the mistake that, my Lord, we can go through the list of mistakes that we've made if we want to list them out.
But it seems bizarre that you're, on your story, in a better position after you've been debarred than before you're debarred. It seems very odd.
Well, my Lord, had we pointed it out, I think the judge in the slip rule judgment does posit what he would have done. With the benefit of hindsight, yes, we should have at least tried to have pointed it out.
I mean, I think in the slip rule judgment, the judge says, well, if Mr. Bell had pointed out the problem, then he doesn't think he'd have ignored it.
Yeah.
But he does then go on to say that there would then have been all sorts of other problems.
Yes, yes. And you know, we can't get around, and I don't seek to get around, the fact that if things had been spotted at an earlier stage, we wouldn't have had to come before this court, or may not have had to come before this court. My Lord, taking up the point that my Lord Justice Arnold was effectively putting to me, perhaps appropriate to then look at the next order, which is on page 179. So, my Lord, directions are it's recorded that the defendant accepted that it was debarred from defending because it hadn't complied with the order. And then there are various directions given with regard to the information that the claimants were to provide. The spreadsheets referred to at 1, updated schedules of interest at 2. I should have said this is this is now before the Deputy High Court Judge, Mr Edwin Thompson, Queen's Counsel, as he then was. And over the page at 181, there was to be provided the spreadsheets and supporting documentation, and it was to be provided electronically. So the matter is now proceeding on the basis, we say, of the evidence that is being put before the court with regard to, the evidence that is being put before the court with regard to the account, that evidence being from and lodged by the claimants. And the account hearing then proceeded relying on the documents that the claimant had put before the court in those spreadsheets that are referred to there. Now, if both parties were under, assuming that both parties were under the misapprehension with regard to tax, we say, can it be right in that situation that the claimants who've put those spreadsheets, etc., before the court, can it be right that the claimants should, as a result of that common misapprehension, be entitled to some £2 million or so? But we also say that if it was not a common misapprehension, and our submission is that it must have been, but if it was not a common misapprehension, then the judge should have been addressed on the figures that were being put before him with regard to the tax element. As I say, I don't suggest one moment that there was anything other than a common misapprehension. My Lord, it was because I assume anyway that my learned friend Mr Bell thought it was so obvious what had gone wrong that the application was made under the slip rule. Because there had been, on the face of it, we say a miscalculation as to what the claimants were entitled to, the sums that the claimants were entitled to. That was a belt, if you want to like, it was a belt and braces approach in that the appeal was also lodged. And, my Lord, it's for that reason, obviously, we know what the judge, albeit post the decision that's the subject of the appeal, but we know what the judge who considered the matter thought about it. And often before this court, you know, it is rightly said by the court, well, we've no idea what the judge would have dealt or thought at this point. We can't possibly surmise what the judge may have considered appropriate or inappropriate, or what he would have done if this had been said or that had been said. That is we submit the unusual aspect of this case in that the judge who took the account has made clear the basis upon which the account was taken and the basis upon which the account should have been taken. Now, the result of that is that the claimants have a significant windfall, and obviously the defendants have a significant loss. Now, all sorts of blame can be perhaps ascribed to all sorts of people involved in this, but the issue is whether, so far as this court is concerned, the decision on the taking of the account was wrong, and if it was, whether this court is whether it's appropriate for this court to intervene. We submit that it is. It's not a case, for instance, where there's a change of position and the money's been spent or anything like that. There's an adjourned interim third-party debt order pending the outcome of this. The balance of the claim has been paid. If my lords are not with me in relation to this appeal, well, the claimants benefit to the tune of £2 million on what we say was a basis put to the court which was not open to them. And whilst we were not there to, were not permitted to defend the matter, this court, we would submit, should be slow to endorse an approach that resulted in such a significant error being made, we say, by the court.
Can I just take you back to the YQ issue?
Yes.
I think you recognise that because of that, or possibly because of other things as well, there would need to be a further hearing. But I think you were suggesting that actually it wasn't really a problem, or wouldn't really be a problem on examination. Why wouldn't it be a problem on examination?
Well, under the new agreement, YQ merged with the fare anyway. So, on the face of it, it's not a separate element anyway.
So if we take a sample ticket, I won't try to find one, where we see gross price, whatever it is, tax stroke fee, balance payable. On your case, where would YQ come into that?
Forgive me, Lord, I misheard the first bit. It would come in. It would come in the first figures. It would be part of the fare on which the claimants were entitled to 7%.
Yes, and if we look at, say, page 318.
318. Thank you very much.
That's, I hope, the one you've shown us before. Certainly, what I thought I was looking at when you were making the submission to tab 49 as the supplemental.
Yes.
I hope that's the page we've been to before. Do we know whether the YQ is in the 340 on the top row or the 207?
Well, my lord, we say it's in the 340.
But do we know that? Without any further
I think there is an issue with regard to it, and in case I have misspoken in any sense, let me just. I think, as I'm grateful to my friend, Mr. Bell, it should be in there. It should be in the 340 because that's the effect of the statement of practice of that we sent to our agents. So if we've done what we told our agents we were doing, it should be in there.
Is that based on evidence that was before the judge?
Forgive me?
Is that based on evidence that was before the judge?
Well, the statement of practice was before the judge.
The link to explain whether the right number to use is 340. Is that
Well, I mean, the reality, my lord, is that the judge didn't go to these documents.
I understand. But
Exactly.
you understand the point of my question, obviously. The point of my question is whether you can actually do the YQ calculation in any way, whether it's by deciding you don't have to calculate it even, on the basis of not permitting your client to file any more evidence of any sort. That's what I'm still trying to get to the bottom of, and I'm not sure I've quite got it yet.
Well, I apologise, my lord.
That wasn't certainly not intended as a criticism. I'm just trying to understand. I get that your cases, the number to plump for is 340. I understand that, and you've given me reasons why it would be, but I still haven't quite understood whether a judge without any evidence would be able to be satisfied that that was the right thing to do.
Well, I think I'd have to accept that if a point of dispute is raised with regard to it, that the judge would have to determine that on evidence.
Right.
We would obviously point to the statement of practice that says that under the new agreement it's merged, which, as it happens, would also accord with the Iata resolutions, because Iata resolutions are that element should be included within the sum on which a commission is based.
Can we just sort of take that forward? So suppose that the appeal is allowed and the matter is remitted. At the remittal, you are not allowed to defend. You can't put in evidence explaining this.
Or make submissions.
Or make submissions. On the material before the judge, it's not obvious whether YQ is included in this or not.
My lord, all I can say is what our position is, that YQ is included, as we understand it, in the first sum. If that is not accepted, then the claimants would presumably themselves seek permission to adduce further evidence with regard to the YQ element.
Well, they might not. They might say, look, Judge, well, I suppose at the remittal stage, perhaps they'd have to. But otherwise, they say, well, look, the judge just couldn't work this out at trial. So it can't be taken any further without further investigation. And it's really not appropriate for the Court of Appeal to allow an appeal in circumstances where there would need to be further investigation.
Well, my lord, if the account should have been taken on the basis of figures exclusive of tax, then the court on remittal would expect the claimants to say to the court, this is the tax element. Now, whatever they say is the tax element, we're not going to have an opportunity to challenge that because we've been debarred. But if their evidence was there is no tax element, no judge is going to believe that. Because we know that there's tax on airline tickets. And they know there's tax on airline tickets. And when they sell the tickets to the clients, I dare say they have to explain that a huge amount of it is for tax. So they are going to have to say to the court, this is the tax element.
So this brings me back to the question I asked before, and let me see if I've understood where we've got to correctly. When we look at page 318,
318, yes.
I will take the example that I took before because it's a relatively neutral example, which is the heading document number.
Yes.
Now, as I understand where we got to, there was no evidence before the judge on the taking of the account which explained each of the headings in this document. Thus, in particular, there was no evidence before him which explained what was meant by document number and whether it was the same as ticket number or different. Have I got it correct?
Well, there was no evidence as in setting out in a witness statement that saying that equals ticket number. Obviously, if one had gone to the, it would take weeks, but if one had gone to the exercise of comparing each of those with the native format information from BSP, that could have illustrated that.
So I thought this was the native format information.
I'm sorry, my lord's quite gracious. If one had gone to the spreadsheet where there is the reference to, forgive me, I've put it around the way.
Just on the ticket number point, I wondered whether one could find a tallying between the column in the document at tab 49 and the tables in the lists of objections. But I think they all relate to different periods. What I mean is if you take, say, page 256, three lines from the bottom on
yes.
Ticket number and various ticket numbers are shown. But I don't think those particular ticket numbers are within the scope of the document we see at tab 49. Because tab 49 I think is just January 2013 and January 2014. I don't think these particular tickets come from January 2013 or January 2014.
Yes. My lord, I think, well, certainly those three on 256 aren't in the periods referred to in the samples exhibited at 318 onwards. No.
Are these even the same number?
I think Ms. Buff is going to help us.
I've sought to reconcile them. Unfortunately, the examples given in the mini schedules don't tally with any of the dates given in, if you like, the BSP reports.
And when you say the mini schedules, you mean
I mean the ones exhibited, yes.
beginning at 268, for example?
Yes.
Yes.
Yes. And in terms of, to assist Justice Arnold, the ticket numbers are a 13-digit number and the document number is an 11-digit.
I was about to raise that question.
Yes,
I'd noticed there was a difference in the number of digits.
Yes.
So they can't be the same.
No.
Yeah.
Well, my lord, I'm not going to be able to take that point any further.
But the point is, the significance of the point is this. We come back to where we started at 10:30 this morning with my Lord Justice Newey's first question, which was the status of Mr Malik's evidence. Because when we came into court, we were operating on the assumption that you were going to be applying to adduce Mr Malik's statement as fresh evidence. You disabused us of that assumption and said, no, you're not relying on Mr Malik's evidence as fresh evidence. So therefore, you have to be in a position to say that the alleged error is apparent from the evidence that was before the court. And the only real material you've got is what we've got at 318. And 318 is a document which is not self-explanatory, as is tested by looking at the document number. Because when I inquired, was that the ticket number? Ultimately, you said on instructions, yes, it was, but as Ms Murphy points out, it can't be because it's a different number of digits. So, we are in the position where you're relying upon a document which is not self-explanatory. It requires evidence to explain it.
Well, my lord, can I go back to the reason why I haven't sought to rely on or explain why I haven't sought to rely on the evidence of Mr Malik? As has been pointed out to me on a number of occasions, we were debarred from defending the matter, and to seek to put evidence before this court when we weren't allowed to put it before the court below struck me as something of a brave submission.
I mean, it would reasonably have been available, but for the fact that you were debarred.
Correct. So we weren't allowed to. I mean, yeah, maybe. We were not allowed to put such evidence before the court below. So it seemed to me that this court would be reluctant to admit it now when we could, and but for our own conduct, have put it before the court below.
Well, that's very realistic, if I may say so. But it brings us back to this problem because you said, well, you can all work it out because you can marry up the ticket numbers. But if the document numbers are not ticket numbers, which on the face of it they're not because they're a different number of digits, then how can you marry it up?
Well, my lord, the direction was for the claimants to produce in native format the BSP PDFs. So all of those PDFs, however many, obviously they were never all printed off because there were thousands and thousands of them, but all those PDFs were electronically before the court. If those are the underlying documents, then they must be the documents that support the schedules and the spreadsheet. So, if one then looks at them,
remains, how do we know that the error that you allege was made was in fact made? And I appreciate that you get a certain amount out of the fact that there's the gross fair cash heading and the tax fee cash heading and then the payable balance, and you can draw to some degree an inference from that. But that is not a complete answer because, as we've been over already, you still need to know whether the figures that were before the judge are tax inclusive or tax exclusive. And when you were asked about that, you said, well, you can find out the answer because you compare them ticket by ticket. But that is only right if the document numbers are ticket numbers.
No. I thought you put it slightly differently in the end, which was that if you totted up all the figures in the BSP material, you would find that they matched the total sales figures given in the schedules by the claimants.
yes.
Now, admittedly, that isn't proved, but that.
But that is
Where's the evidence of that?
what that would be the result.
Yes.
Well, if it was not the result, then the claimants had failed to put the evidence before the court because they were supposed to put the supporting native documents there.
Yeah, but you need to know, is it tax inclusive or tax exclusive? That's the question. How do we know, without extrinsic evidence, that the figures that were before the judge were tax inclusive rather than exclusive?
Well, my lord, in our submission, we do know, but I accept that the issue is how do you actually show it from the evidence that was there. My lord, so far as the ticket numbers are concerned, I haven't gone back to check this, but it may be that each ticket on the ticket number schedule has had inserted in it the numbers 214.
I beg your pardon, can you give me the page reference again?
Well, it's the
268, for example.
268, yes.
I mean, I have to say, Mr. Kirby, that the fact that on page 256 the three ticket numbers all have a prefix of 214 doesn't fill me with confidence that that's all you have to do to.
Well, my lord,
It can't be right. If you add 3 digits to 11, you get
Well, my lord-
14, not 30.
my lord, I was. I hope my lord will accept that I was about to come back to my lordship and say, no doubt, my Lord Justice Arnold will make the point that 11 to 13 isn't made up with another 3 numbers.
Well, it's better. I wonder whether there might be an answer to that. So if we take, say, 256, that's 13 digits, is it? 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 digits. So if you took off 214, we'd get to 10 digits. And if you go to the document number, say at 318, I think before you add on the 0, it's 10 digits, is it? I think it's 10 plus then separately a 0, 1, 2, 3, 4, 5, 6.
Which appears to be under possibly a different heading.
So it may be
CD, that appears to be.
But there's actually a comparison between 10 and 13, and then
Yes.
the 214 prefix might work.
But then you need evidence about what that last digit is. I mean, it might be a hash value, but who knows? Something like a hash value.
I mean, I could see that the material before the judge included not just the sample BSP material we have at tab 49, but all of it.
Yes.
And so from the material before the judge, one could have worked out simply as a matter of arithmetic, had anyone done it, what the gross and net sales figures by reference to these columns were for any particular period, and one could then have compared those with the claimant's schedules, for example, at page 285, and one could have seen whether the total ticket sales for, say, the 1st of November 2012 to the 31st of December 2012, given as 2.281 million, match the total for either of those columns. So potentially that was possible to work out from material before the judge. We don't actually have proof of that before us.
Well, but we certainly don't have all the PDFs before you.
But neither has anyone attempted to do the exercise, as far as I know, of totaling these columns for the particular periods.
Well, there's no evidence before you about that. I take instructions, but there's no evidence actually before you on that point.
Yeah.
I mean, I accept this is possibly too simplistic a way of looking at it, but it seems to have an element of common sense to it. Are the claimants asserting that the evidence they put before the court in relation to these figures was exclusive of tax? It's never been, well, in my limited involvement in the matter, it's not been my understanding that the claimants are asserting that. And we submit that in seeking to hold on to what we submit is a windfall of over £2 million, that's not the most attractive of stances to take. Now, I've had, quite rightly, a number of criticisms levelled at this side because of being debarred. We're trying to get better result now. What we are submitting is that the claimants did not and have not suggested that they adduced evidence of the figures exclusive of tax. If their submission was that these always were exclusive of tax figures, then there's very little I could say, having been debarred from defending. But unless that is their stance, You are being asked to dismiss this appeal. You will be asked by my learned friend to dismiss this appeal. In a situation where the claimants now know, even if it was a misapprehension at the time, now know that £2 million worth of their judgments was...
Yes, but one answer to that is that, and it's only a hypothetical answer, but they might know it as a result of Mr Malik's evidence, when you're not seeking to rely upon Mr Malik's evidence. The question, perhaps more accurately, is whether they should have known on the basis of the evidence that was before the judge. And you haven't actually even alleged that. So the fact that they may now know as a result of evidence which you're not relying upon, where does that get you?
Well, they should have known, so far as the evidence for the judge is concerned, because Mr Ahmad says, and I realise that my lord didn't necessarily agree with what I suggested was clear language, but they should have known because their evidence is that they had access to the various component elements, including the taxes. So they should have known when they put...
You said earlier that it was a common misapprehension.
Well, the fact something is a misapprehension doesn't indeed almost, I would submit, follows if something's a misapprehension that people should have realised. I cannot and do not allege any form of fraud on the part of the claimants, but I do submit that they should have realised that the figures they were putting before the court were not the ones for which directions had been given.
So just picking up, I think the point you were alluding to there, you say when Mr Ahmad, for example, says that he was providing figures based on cost price paid to PIAC via BSP, you say that naturally connotes the tax inclusive figure.
Forgive me, my lord. Inclusive or exclusive?
Inclusive. I mean, if Mr Ahmad is saying he's prepared a schedule based on cost price paid to PIAC via BSP, you have to, I assume your case is that he was preparing the schedule by reference to tax inclusive figures.
Yes, yes.
And therefore, you would ask us to infer, would you, that when he says he's doing it by reference to cost price paid to PIAC via BSP, that connotes the tax inclusive figure?
Yes. Sorry, forgive me, I was being slow. Yes, yes, indeed. Having turned to the page, I've actually annotated my note that says brackets will have included tax. So yes, yes, that's exactly.
Just give me the facts. Let's say the facts were that it was correct as a matter of law, decision, pleadings, orders, and everything else. The right figure to use was the exclusive of VAT of tax figure, which is part of your case, and that was start from there, and that you can say fairly that the claimants ought to have known that or did know that, but nevertheless, in fact, as far as one can tell, or at least one can assume for now, that there was an entirely innocent mistake on their part. They didn't realise that the numbers they were advancing to the court were different from that. They thought they should be, on this hypothesis, be using the tax figures, but in fact the numbers weren't, and your client didn't spot it either. So both parties, in that sense, have made an innocent mistake, and the case has gone to trial and conclusion based on a common innocent mistake. The question then is, after the event, on whom does the loss fall?
Well,
arising from that.
If there's a common innocent mistake,
That's your case, isn't it?
yeah, yes, yes, yes. But sorry, I thought
No,
we were talking hypothetically. If there is a common innocent mistake, my lord, we would submit, as we do in this case, and as well as the hypothetical, we would submit that that has a significant impact on the outcome, that, my lord, this court should be prepared to intervene in that. Because the court and the parties have all been operating under a common mistake. Now, my lord, I taking the point that was made earlier with regard to fraud, which we don't allege. Obviously, if it was fraud, we could apply to set aside that judgment. But in the absence of fraud, the only option that the party who has lost out by reason of that common mistake is either to persuade the other side to, if you like, do the decent thing. Well, why would they if they've got their judgment? Or to come to this court, assuming that it's not an admitted mistake. Because if it's an admitted mistake, my lord, I would suggest that we may have succeeded in relation to the slip rule. But if it's not an admitted mistake, then we come to this court and we say that the decision was wrong.
Now, I think that while the clock may say 7:45, it is in fact...
I've been talking a long time, in which case...
More or less 1 o'clock. My hypothesis is that as we've quizzed you, you've covered your ground. Is that a fair assumption, or will you wish to continue after the shorter time?
Well, my lord, I have not followed at all, other than the opening 3 lines, the order in which I was intending to go. So perhaps I could have just the lunchtime just to check that one way or another I've covered the points.
Yes. So we'll break now and resume at 2 o'clock.
All right.